Hey guys, and welcome to today's video. Today we have a sovereign citizen who racked up a $30,000 credit card debt and didn't think that he'd have to pay it back. That was until the credit card company took him to court. Now, this video is going to be a little different than what I usually do since there isn't much need for commentary on this video. It was over an hour long, so I'm going to cut out the procedural and boring parts and let the important parts of the video play, like the sovereign citizen cross-examining the witness, and then I'll give my thoughts at the end. So, let's begin.
And we are on the record for the 21st Judicial District, Division 10, involving U.S. Bank National Association versus Adam Dietrich, case number 25 CV 3023. We're here for trial of this matter today. I'll let plaintiff's counsel commence with any preliminary issues that we need to address.
Your Honor, Alex Adams for the plaintiff.
Thank you, Mr. Adams. Are there any preliminary issues that you need to address before we start with testimony?
I do not believe there are any preliminary issues, no.
All right. And who appears for defendant?
It's Adam Dietrich.
Thank you, Mr. Dietrich. And are you here representing yourself today?
Yes, Your Honor.
And do you have any preliminary matters that you'd like the court to address?
No.
All right. Mr. Adams, I'll let you go ahead and proceed to call your first witness.
Thank you. The plaintiff, U.S. Bank National Association, would like to come.
I'm sorry. I get into the habit of just like jumping into hearing mode. If either of you would like to present opening remarks, you are more than welcome to. I jump right in and my apologies. If you'd like to present some opening remarks, I'm happy to hear them.
Sure, I can
Thanks.
have some quick remarks. So this is a simple debt collection action to recover an unpaid balance on two credit accounts. The plaintiff, U.S. Bank National Association, will show that it is entitled to a judgment for breach of contract on both accounts. The claims are brought by the plaintiff to enforce the terms of the card member agreements, and the defendant has breached those terms by failing to make payment.
I object, Your Honor. This is hearsay.
Oh, sir, Mr. Dietrich, these are opening statements. The rules of evidence don't apply to opening statements. He's simply telling me what he expects the evidence to be.
Okay.
And you'll have the opportunity to do the same thing. So objection is overruled and you may proceed, Mr. Adams.
Thank you. Consequently, the defendant is liable to the plaintiff for the principal amount of $30,002.94. The evidence presented will reflect that there is no dispute to the validity of the contracts, the stated accounts, and the amount of damages. And the defendant will not be able to show evidence to refute the plaintiff's claims. The plaintiff will prove by preponderance of the evidence that the defendant has damaged the plaintiff in the amount of $30,002.94. Excuse me. And the plaintiff is entitled to a judgment. Thank you.
All right, thank you very much. As I was previously explaining to you, Mr. Dietrich, you now have the opportunity to also make an opening statement, or you can wait and do so at the beginning of your case in chief. Do you want to present one now, or do you want to wait until after the plaintiffs have presented their evidence and give one then?
Yes, Your Honor. I can give a brief statement now.
I will be happy to hear from you. Please go ahead.
As implied surety, beneficiary, and subrogee, the plaintiff has refused to provide the four elements of a valid contract, thus never validating or verifying the debt. They have refused to provide the full accounting of the alleged debt. The witness does not have any firsthand perfected knowledge of the material facts in this case. Bank statements are hearsay and thus not admissible.
Thank you. Do U.S. Bank National Association's records reflect that the defendant defaulted?
Yes.
And referring to both accounts, why are these accounts in default?
For a defendant's failure to make the minimum payment.
Thank you. And as a condition of the continuous default on the accounts, did the entire balance become due and owing on both accounts?
Yes.
Thank you very much. No more questions, Your Honor.
All right, thank you very much. Mr. Dietrich, you have the opportunity to cross-examine now if you would like to. Would you like to ask questions of Mr. Gifford?
Yes, Your Honor.
Go ahead.
Mr. Is it Gifford?
Yes.
Okay. So as a reminder, you are under oath, penalty of perjury if you do not tell the truth, the whole truth, and nothing but the truth regarding your firsthand perfected knowledge of this material facts of this case. Do you know the definition of firsthand perfected knowledge?
I'm sorry, did you have a question about the account or?
He
I'm
did ask,
asking, do you know
he has,
the definition of firsthand perfected knowledge?
I'm just not sure what the question's relating to for this account.
sir, you do need to answer the question.
No, I don't have the definition on hand.
You do not know the definition of firsthand perfected knowledge? Okay. Is looking at a computer screen firsthand perfected knowledge?
I don't know.
Have you ever been employed with U.S. Bank?
Yes, currently employed with U.S. Bank.
Did you see a certified copy of the original wet ink signed contract between the plaintiff and the defendant?
I'm sorry, can you say that again?
Did you ever see a certified copy of the original wet ink signed contract between the plaintiff and the defendant?
We don't have written contracts, it's card member agreements.
So is that a yes or no? Did you see a wet ink signature contract between the plaintiff and the defendant?
No.
No. Are you a certified public accountant?
No.
No. What are the general accounting rules of credit card accounts? AKA GAAP.
I'm not an accountant. I can't answer that.
Right. Thank you. What is a T ledger?
I'm sorry, can you say it again?
What is a T ledger?
A T ledger. I'm assuming that's something with accounting again. I'm not an accountant.
Okay. So did you look at both sides of the ledger? I'm assuming that.
We don't have a ledger that I review for credit card statements.
Okay. What is the meaning of full accounting of an account?
Give me 1 second.
You need to Google that.
Yeah. I don't. I mean, full accounting. I don't know what that's in relation to.
You don't know?
No.
No. Okay. Did you know that the plaintiff was requested to provide a full accounting and that they have refused to provide it?
If you're talking about the validation of debt, that was satisfied.
No, provide a full accounting of the account, and they have failed to provide it. Are you aware of that?
I'm not aware of any such request.
Do you know what concealment is? It's when you refuse to provide exploratory evidence that would exonerate the other party and that the concealment is fraud. Have you or the plaintiff concealed the full accounting when asked for?
No.
Do you know what collateral securities are?
I do not.
So were there any evidence of collateral securities associated with these accounts?
It's unsecured debt, so I don't think there would be collateral involved.
Do you know if there are collateral securities associated with this account?
Again, it's credit card debt. It's unsecured.
Okay, you're a witness. I'm just asking questions. Remember, you're under oath. Do you have any firsthand perfected knowledge that the defendant contracted with the plaintiff?
Objection, Your Honor.
Basis of
Asked
your
and answered.
objection? Sustained.
Sorry, what was that? the screen
There
cut
was an
out.
objection that you have already asked that question, and indeed you did ask him about firsthand. State your question again.
No, I was asking if he has
Yeah.
any firsthand perfected knowledge
Of
that the defendant contracted with the plaintiff.
So previously you had asked about his knowledge of the term firsthand perfected knowledge. So I'm going to
Right.
overrule the objection for asked and answered. Mr. Adams, do you have any other basis for your objection?
No, Your Honor.
Go ahead and answer.
Sorry, can you state the question one more time now?
Yeah, no problem. Do you have any firsthand perfected knowledge that the defendant contracted with the plaintiff?
Firsthand knowledge, no.
No. Okay. Do you have any firsthand perfected knowledge that the defendant financially harmed the plaintiff?
Firsthand knowledge, no.
No. See, therefore, Your Honor, I move that this witness be ruled incompetent and all their testimony be stricken from the record.
Do you wish to respond, Mr. Adams?
Yes, this witness has already been qualified as an operations manager, a custodian of
I would
records.
object to that.
Hold on, let him finish and then you can present your response. Go ahead.
Based on this witness's responsibilities with U.S. Bank National Associations and familiarity with the business records and the record keeping, this witness is a qualified witness.
Okay, so Mr. Dietrich, what you're trying to get to when you're talking about this firsthand knowledge is an issue that would be relevant if we were dealing with the capacity of hearsay. But because these records fall within the exception to the hearsay requirement, his firsthand knowledge is covered by that business records exception. So he has testified that he has firsthand knowledge of how U.S. Bank conducts its ordinary course of business, how they send their statements, how they keep track of the bills, how they keep track of the payments that are made, how they keep track of the requests for payments that come in through their electronic systems. That renders him competent as a witness as to the things that Mr. Adams presented him as a witness on. So I'm going to deny your motion to strike him as a witness. You may proceed with your cross-examination.
Is there any evidence that I'm the debtor?
Yes, that would be the card member agreements and the card member statements that you received at your address.
And again, just for the record, I've requested evidence of a contract, and there has been none sent to me. I have no further questions, Your Honor.
Objection, Your Honor. The contracts have been admitted as Exhibits 1 and Exhibits 5.
Okay,
I would
so
object to that.
we're going to back up a hot minute. The statement that Mr. Dietrich made wasn't a question, and so it was not properly submitted to this witness. And I'm going to sustain an objection on that ground. Mr. Dietrich will have the opportunity to present his own testimony, and if he wishes to present that statement at that time, then I can consider it at that time. But it's not a proper commentary on this witness's testimony at this time in the proceeding. Do you have any redirect questions you want to ask, Mr. Adams?
Yes.
Go ahead.
Mr. Gifford, right, based on the card member terms and agreements for both of these accounts, you stated that use is acceptance of the agreement. Did the defendant use these credit accounts?
Yes, both accounts.
And again, earlier you stated that default on these accounts could be by failing to make payment. Is that correct?
That's correct.
Did the defendant fail to make payments on these accounts?
Yes, for both accounts.
And is the defendant in default?
Yes.
Thank you. No more questions.
Thank you very much for your testimony, Mr. Gifford. Mr. Adams, do you have any other witnesses?
No more witnesses.
Mr. Dietrich, do you have witnesses you would like to present?
No, Your Honor, I do not.
Do you wish to present testimony on your own behalf?
No, Your Honor. I would ask.
Go ahead.
I've tried to explain that there's no evidence of a contract yet, as of yet, which I've asked for. I've sent verification and letters. They were ignored. Also, throughout the filings in the courts.
Mr. Dietrich, I'm going to, what you're presenting what I think are closing remarks, but you're addressing some things that are not yet in evidence. Are you sure you don't want to provide testimony on your own behalf?
I can provide a testimony.
Raise your right hand. Do you solemnly swear that the testimony you provide before this court will be the truth, the whole truth, and nothing but the truth, subject to the penalty of perjury?
Yes, Your Honor.
When you're testifying on your own behalf, you don't have to ask yourself questions. You can just tell me the important factors you think I should consider. Go ahead.
Can I recuse that? I would rather not.
You never have to testify.
Okay,
You can if you want to, but you're not required to do so. If there are facts that you know that haven't been presented yet that you think are important for me to consider, this would be your chance to tell me about those facts.
Yes,
They
there are
need
some
to be things that you have firsthand knowledge of. You've talked a lot about firsthand knowledge today. So if there are things you have firsthand knowledge of that relate to this dispute and you want me to consider them, now is the chance that you have to tell me about those.
Yes, Your Honor. I do have some facts that I know about that I would like to have on the record.
Go ahead.
Okay. The four basic elements of a contract: the existence of a contract, any consideration given by the plaintiff, that the debtor, not the surety, breached an obligation, that the plaintiff suffered financial damages under the full accounting, refused to provide evidence of the original contract, along with refusing to provide the full accounting is concealment of the material facts of this case.
Okay, I'm going to back you up a bit. What you're doing is making an argument, which you get to do. That's a little bit down the proceeding. What I need now are the facts that would support this argument.
I have not received these four elements that I've requested, Your Honor. That is a fact.
Anything else you want me to consider?
No, Your Honor.
Right. Do you wish to cross-examine Mr. Adams? That
No,
came
Your
out
Honor.
funny. I need a comma somewhere. Mr. Adams, would you like to cross-examine Mr. Dietrich?
Yes, Your Honor. Mr.
Go ahead.
Dietrich, I have heard you a couple of times mention being a surety. Can you please explain that a little more?
Yeah, so as signing as a surety beneficiary on the account, the all caps name is identified as a trust account.
A trust account for. Can you please continue to elaborate? When you say it's a trust account, are you saying that this is not your account?
I am the beneficiary of this account.
Mr. Dietrich, is your name on the credit card statements? I refer to specifically Exhibit 7 and Exhibit 3. Is your name and address on there?
There is a name and address on there.
And they're not your name and address?
Have you been able to verify and validate these names and address?
When you say verify and validate, what do you mean?
According to the rules of verification validating debt.
Can you please elaborate?
Again, I am the surety and beneficiary subrogee of this account.
So you were saying that your name is not Adam Dietrich.
I'm saying my name is also like that. I am not the all uppercase name that is presented on your exhibits.
No more questions, Your Honor.
Thank you.
Mr. Dietrich, you have the opportunity to present what we would call redirect. You don't have to ask yourself questions, but if there's any factual statements you'd like to make in response to Mr. Adams' questions, you have the opportunity to do that right now.
No, Your Honor.
Okay. Then at this case, I'll entertain both of your respective arguments. Mr. Adams, as plaintiff's counsel, you get to go first. Please proceed.
Thank you. U.S. Bank has shown that there are valid contracts that exist between the plaintiff, U.S. Bank National Association, and I'm sorry, am I still
You're good.
audible?
We hear you, yes. Can you still
I'm sorry,
hear us?
yes,
Okay, that's fine.
as I was saying, U.S. Bank National Association did have a contractual relationship with the defendant, and as evidenced by Exhibits 1 and Exhibits 5, the credit agreements. Mr. Gifford has testified to the fact that use was acceptance of the agreements, making a valid contract. You have the offer, the acceptance via use, and the consideration is that Mr. Dietrich had the opportunity to use the credit accounts provided by U.S. Bank National Association, and U.S. Bank National Association provided the credit cards that enabled use of the credit accounts. Additionally, Mr. Gifford has testified to the fact and shown based on the exhibits entered, Exhibits 5 and 8, that Mr. Dietrich defaulted on the contracts by failing to make payments when they were due. And as in default, the full balance is due and owing. And Mr. Dietrich has damaged the plaintiff for the amount owed, which is a total of $30,002.94 with both accounts. That is still owed to the plaintiff. That is what is damaged. And based on the breach of contract, the plaintiff is judgment, or the plaintiff may receive judgment. Thank you.
Thank you. Mr. Dietrich, do you wish to respond?
Your Honor, I asked this case to be dismissed with prejudice as the plaintiff under the intent of FRCP Rule 12b-6. The plaintiff has not stated a claim on which it can be granted. The plaintiff has refused to produce evidence of the 4 basic elements of contract, which I spoke to earlier, the existence of the contract. Any consideration given by the plaintiff that the debtor, not the surety, has breached an obligation, that the plaintiff suffered financial damages under full accounting, is concealment of the material facts in this case. Concealment is fraud. I'm not an attorney, but and fraud vitiates all contracts. Therefore, I demand this to be dismissed with prejudice.
Thank you. So you've referenced Federal Rule of Civil Procedure 12b-6. We don't follow the federal rules. This is state court, but Colorado does have a similar 12b-5, which would be motion for failure to state a cause of action that is typically addressed earlier in the proceedings. What you're really asking me to decide is whether or not the plaintiff has proved his cause of action for breach of contract And so I will address that accordingly. As you have reflected, the elements that are necessary for a breach of contract are that there was a meeting of the minds between two parties, that meeting of the minds set forth certain agreements that the parties agreed on, that one party received the benefit of that bargain and that the other party was damaged for one side not having complied with the benefit of that bargain. So we have to have an agreement. We have to have terms and conditions of that agreement that are sufficient to establish what the agreement was, that a person of ordinary prudence could establish. Then we have to have a breach of the agreement. We have to have actual damages for there to be a claim for breach of contract. The evidence before this court establishes that there were two credit cards opened, a Platinum Visa credit card on a U.S. bank account and a Harley, exactly what that one was called. A Harley Davidson Visa Rewards card also opened on U.S. Bank. The statements in those, the statements for those accounts reflect that items were purchased. The testimony of Mr. Gifford establishes that U.S. Bank paid money to third parties for those items. Mr. Dietrich has conceded that he is the beneficiary of these cards. Thus, the court can make a sufficient inference that he received the goods that were paid for, as reflected in the statements that bear the name Adam Dietrich. Admittedly, the name Adam Dietrich is typed in all caps on these statements. Mr. Dietrich takes issue with whether or not that is indeed him, as opposed to him in some form of trust. There has been no evidence presented to this court that there was a lawful and valid trust established under the laws of the state of Colorado that would have opened and held this credit card and that would have been responsible for the payment of this credit card. The evidence before me is that Mr. Dietrich, as the admitted beneficiary of the goods of these accounts, has received the goods, did have knowledge of the accounts, did use the accounts. The information contained in the card agreement says that use of the accounts is acceptance of the agreement for the account. That's what created the valid and binding contract. Mr. Dietrich raises concern with whether or not a sufficient accounting has been presented to him on these credit card accounts. The statements themselves are the accounting that the statement agreements agreed would be accepted as the accounting. It doesn't have to be set forth in a 2-column ledger type of system that Mr. Dietrich was inquiring about, because that's not what the card agreements called for. The agreement between the parties indicates that the statements would be the accounting for the account. This is not a circumstance where someone else opened the account and Mr. Dietrich didn't have any knowledge about it at all, and someone else used the card in Mr. Dietrich's name, and he didn't get the benefit of the purchases. No evidence to that effect was presented to the court. That might create a different result, but there was certainly no evidence that Mr. Dietrich did not receive the benefit of these accounts. And on cross-examination, he confessed that he is indeed the beneficiary of these accounts. And so I am going to find that there was an agreement made on both accounts between Mr. Gifford and certainly for the benefit of Mr. Dietrich, that charges were made on the accounts, that U.S. Bank paid for the items that were made as a result of the charges on the account, and that it's reasonable for the court to infer that Mr. Dietrich did receive those goods. Thus, and that he has not paid these statements as is reflected by the evidence before the court. And thus, U.S. Bank has satisfied its burden of proving by a preponderance of the evidence that Mr. Dietrich is responsible for the amounts due on these accounts, and the court will order that Mr. Dietrich is required to pay the balances of the accounts, which specifically as to the Harley-Davidson account was $13,809.96. And specifically as to the Platinum Visa account was $16,192.98. Mr. Adams, do you have any further requests of this court?
No, Your Honor.
Mr. Dietrich, do you have any further requests of this court?
No, Your Honor. Thank you.
Thank you all very much.
All right, so that's the end of the video. It turns out that even if you think you're a trustee of an estate without a wet ink signature on a cardholder agreement, you can and will still be responsible for the debt you incur when you use that credit card. So, if you liked the video, then hit the like button. If you disliked it, then hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic and I'm out. Here we